Hello and welcome viewers. You're watching In Depth with your host Kriti Mishra, a platform where we break the most complex issues of the world and our country in just 5 simple questions and their 5 simple answers and help you understand how these issues matter to you. The Supreme Court has said forced religious conversion is a very serious issue which can affect national safety, freedom of religion and freedom of conscience. The top court asked the central government to file an affidavit detailing what steps can be taken to curb such forced conversions. So what is the case? Well, a bench of Justices M.R. Shah and Hima Kohli was hearing a public interest litigation seeking directions from the centre and states to take stringent action against forced religious conversion carried out through intimidation or by luring people using gifts and monetary benefits. The bench called such forceful religious conversion a very serious matter and said it is time that the centre steps in to stop them before the situation becomes difficult. Solicitor General Tushar Mehta, appearing for the centre, assured the bench that the issue was debated and the government is conscious of the situation. He added that the government side will file their response. So what is forced religious conversion? Well, religious conversion is the adoption of a set of beliefs identified with one particular religious denomination to the exclusion of others. Thus, religious conversion would describe the abandoning of adherence to one denomination and affiliating with another. People convert to different religion for various reasons, including active conversion by free choice due to a change in belief set, conversion for convenience or marital conversion. But forced religious conversion is the adoption of a different religion or the adoption of irreligion under duress. So what is the need for anti-conversion laws? Well, the Constitution confers on each individual the fundamental right to profess, practice and propagate his religion. In the recent past, several instances have come to the notice whereby people marry persons of other religion by either misrepresentation or concealment of their own religion, and after getting married, they force the other person to convert to their own religion. And what is the status of anti-conversion laws in the states? Well, there is no central anti-conversion law. Over the years, the state governments implemented freedom of religion legislation to restrict religious conversions through force, fraud or allurement. Freedom of religion laws are currently enforced in Odisha, Madhya Pradesh, Arunachal Pradesh, Chhattisgarh, Gujarat, Jharkhand and Uttarakhand. Madhya Pradesh, Uttar Pradesh and Himachal Pradesh passed anti-conversion laws that outlaw religious conversions solely for the purpose of marriage. While the common feature of these laws is the declaration of such marriages as null and void and penalizing conversions done without prior approval of the state, they differ in several aspects. So what is the history of anti-conversion law in India? Well, princely states headed by Hindu royal families were the first to introduce laws restricting religious conversion during the British colonial era, especially during the latter half of the 1930s and 1940s. These laws were enacted to preserve Hindu religious identity amid British domination. There were over dozens of princely states with such laws, including Kota, Bikaner, Jodhpur, Raigad, Patna, Sarguja, Udaipur and Kalahandi. Independent India also witnessed the introduction of anti-conversion bills in Parliament, though none was implemented due to the lack of political support. Well, that's all I could pack for you in this edition. Thanks for watching and stay tuned to Sansad TV. Goodbye from my side for now.